Can felony cases be dismissed? Facing a felony is one of the most serious things that a person can encounter in their lives. Felonies range from state jail felonies, which are punishable by 180 days to 2 years in state jail, all the way up to a capital felony for which the death penalty can be imposed. And there's a huge range of punishments in between state jail and capital punishments. Regardless, any felony is something that could affect you for the rest of your life. Having a felony conviction is something that future employers will look at. Any lender would look at. Your opportunities to go to school, your ability to vote or possess a firearm are all affected by whether or not you have a felony conviction. So whether or not a felony case can be dismissed is an important question. Felony cases can be dismissed. Understand felony dismissals are pretty rare. And there are a number of ways to end the criminal process when you're facing a felony charge. First and foremost, cases can be dismissed by negotiating. Typically, finding a weakness in the case that is profound enough to shake the prosecutor's confidence in any of the elements of that case will be sufficient for dismissal, but not always. Sometimes it's a combination of finding weaknesses plus the mitigation information that the defense attorney provides that leads to a negotiated dismissal. So sometimes you have to jump through hoops, a lot of hoops, and combine that with weaknesses in the case for your case to ultimately get dismissed. Another way to get your case dismissed is to force the prosecutor's hand. What I mean by this is sometimes you have legal evidentiary issues. If there was a bad stop, if the arrest was not based on probable cause, if the search was not based on probable cause, consent, or through some other valid legal mechanism, then that evidence or that stop should be challenged. And if properly challenged in court, if the judge agrees with us, then that evidence gets thrown out. So in a drug case, that might be drugs. In a sexual assault case, that might be DNA evidence. It might be a confession. In a DWI case, it might be a blood or breath test result. But once you take out the state's strongest piece of evidence, the state's hand is then forced to determine whether or not they can proceed without that evidence. In many cases, they cannot. And so now you force them into dismissing your case. The third way to end a felony case without going to trial is through the grand jury process. This isn't an outright dismissal. It's a no bill through the grand jury. What that means is through a defense presentation, if you can convince the grand jury that there's simply not even probable cause, which is a very low threshold of proof, to proceed as a felony case, and if that grand jury agrees with you, then they're going to vote down and say there's not probable cause to proceed. And if they don't get at least 9 out of those 12 votes that say yes, there is probable cause, then that case is over. It gets no billed if they can't secure those 9 votes. So a no bill or a lack of indictment is sufficient to end the proceedings in a felony case. We're making these videos in response to questions that we've received here on our YouTube channel or through our website. So drop a question below if you have any question regarding criminal law in Texas or federal criminal law, and check out our website, verghese texas.com.